Ladies and gentlemen, dear members and colleagues, on behalf of the Franco-German Office for the Energy Transition, I wish you a good morning. My name is Sven Rösner and I will present today's webinar. I hope that you and your families are well. Thank you very much for having registered and tuned in today for this session, during which we shall take a look at the current evolutions and recent developments in the field of planning procedures for wind parks. Europe has been watching, like spellbound, the price curve of electricity for a year now, ever since gas prices went on an unprecedented hike in the context of Russia's aggression of Ukraine. But this is not the only reason for high prices. It is also due to the fact that many countries lag behind when it comes to the development of renewable projects. In some cases, this becomes particularly visible. Germany, for example, has found it difficult to deploy its potential for new onshore wind parks ever since the introduction of tenders in 2017. Or, like in France, where we received the news the other day that controlled power cuts may be scheduled by January to avoid blackouts. Only half of France's nuclear capacity is running. The 2020 goal for renewable has not been reached, also due to the fact that, like in Germany, permitting procedures were too complex and too long to allow substantial developments. The IEA urges governments to streamline permitting, and we are starting to see the first results in this perspective in Germany. In France, a new law to accelerate procedures is currently underway in Parliament. And it is a great privilege for us to have Anouk Dasset-Felgen and Laurence Durier at BNatSchG in Paris, as well as Martin Altrock and Anna Dost from Becker Büttner Held in Berlin with us today, who will present the status quo and possible evolutions of the legal framework today. Dealing with permitting issues from a legal perspective in Germany and France is their daily bread, and I am sure they will have many interesting insights to share with us. Good morning to you all. We are very much looking forward to hear your analysis in a minute. But before I'll pass over to you, I have a few technical announcements to make. We are aware of the fact that this issue stirs much attention, and that you, our audience, might have quite a few questions for our speakers. You can submit them via the question function of the webinar cockpit. And if you please, do so during the presentations, not after they ended. We will do our best to keep at least 20 minutes for a Q&A session at the end of the webinar, but that might not be enough to answer all of them. We would like to apologize for this eventuality straight away. However, we shall brief our speakers on all unanswered questions after the end of the webinar. Also, the slides of the presentations will soon be available on our website, and you shall receive a notification mail once they are available for you to download. A video recording of the session will also soon be up in the members section of our website. A big thank you to our speakers for agreeing to this. If you should experience difficulties with the sound or the image, my advice for you would be to shut down the webinar plugin and to relaunch it by clicking the link in the notification mail you received this morning. One last thing before we start. At the end of the webinar, you will be asked to participate in a quick questionnaire, which consists of just 5 questions. You can skip that, of course, but if you participate, you will help us to improve our format. And that's all from my side for now. Let's get started. Mr. Altrock, please take over. Have a great webinar, everyone. I'm not sure if your microphone is switched on. We can't hear you, unfortunately. Just 1 second, we will see how we can rectify the problem.
It's not.
No, are we on?
Oh, okay. Now we're
It's
on.
working
Thank
now.
you. So we were on Stummschaltung by the system. So good morning. I'm just switching off my camera that you can listen better to us. This morning is Santa Claus in Germany. All the children get sweets from Santa Claus. I'm not sure if Anna and me are able to present so much sweet things as my boys get this morning, but maybe it's more healthy and of a bigger success if we have not only sweet things but solutions for the problem. Sven Wöster, you already mentioned some important aspects. Thank you for the introduction. And how can we go forward with the slides? You are going forward with the slides. Please come to the next slide. I remember that you are going to that. I think BBH as group may be known by a lot of you. We are a big law firm in Germany, especially big in the field of energy and transformation, and with bureaus all over Germany and also in Brussels, and 600 people working for us. And we have tax consultancy and other technical consultancy as well. Next slide, please. Next slide, please. You can read that if you're interested. That's me. Yeah, I'm partner here since 15 years and leading renewable area fields. Next slide. This is Anna, Dost, colleague here in my team, and we're presenting together. I'm just making the introduction, and Anna will tell you all about the actual status of the administrative law regarding wind energy. Next slide, please. Yeah, and this is our agenda for today. First introduction, and then we come to the problem of the duration of the authorization procedure, which is the crucial central problem. It is too long, as already mentioned, and how can we fasten the procedure to come to the increasing of installed windmills that we need to bring the transition process to a successful end. And then we have, we're talking about the changes in the planning law, the changes in the natural conservation law, and then changes in the building code and spatial planning act, but also in the regional planning law. Next slide, please. And here we go. The starting point was already mentioned. We have a big shortage, not only on gas, but prospectively also on electricity, especially if the gas price is too high to produce electricity out of gas. You know, in Germany, we have the problem that we are still producing too much energy, too much electricity out of Steinkohle, out of coal and lignite, and we have to reduce that, we know, and therefore we really have to increase our efforts to the installed wind and solar capacity. Here you see the current mix, and you see that renewable energies electricity was at about 40% last year, but we looking forward, or we hope to reach 100% electricity field within the next 8 or 10 years, which will be a big challenge for everybody, for the whole system, and especially for administrative law and the whole procedure of getting permission for installing a windmill. Next slide, please. Here you can see the aims, the actual aims within the law for the installation year by year. And you see today, 2020, we will have reached maybe 3 gigawatt at additional installation capacity within Germany. And you see that we should, to reach the Paris aims and to reach our aims, 10 gigawatt installation capacity, just onshore wind up to from the year 2027 and then going on until the 40s. So this is a huge effort. It's really challenging job to succeed with that, and we will see how much good it will work. But yeah, you see the curve, and the more effort year by year we'll have to have within the next 5 years. And if you look on that, and if you see how less or just the little success we had in the last month, then we are not very optimistic that this is easily going, but we really have to, and that's why we are talking today about the acceleration of the planning processes. Next slide, please. We got some help from the EU Commission. As you remember, there is the Repower EU planning as a result or a reaction of the Russian war against Ukraine and the increasing prices for electricity. And this was, and I remember, I think 18th of May of this year, that von der Leyen and Meneer Timmermans came along with these ideas. And one really important thing is to accelerate clean energy transition, and that's where we are. The other main issues are saving energy and to diversify the energy sources. So you know the German Ministry of Economics and the German Chancellor travel around the world to get some LNG and to get hydrogen and to get methanol and ammonium within the next years to get the energy for our system that we need out of green sources. Next slide, please. So the key points of this Repower EU program is, as we respond, as I said, to the war in Ukraine, to diversify the energy supply, to saving as much energy as possible. So we also try not to have too much lights that winter and not too much heating. You know, in Germany it could be very cold, especially in the east. And yeah, so we try that, and on the short perspective, but also on the longer perspective, we try to improve our housing situation and our energy supply in the industry, energy consume in the industry, and we have to go also a lot forward in this field. But the third point is the acceleration of the expansion of renewable energies, and there we see the crucial problem at the moment is not the money, is not the subsidy system, is not that there are not enough people who can build that, or enough enterprises that are able to plan that and to realize that. But the time is the problem, that we need too long for all these that we have to do until we can start with producing electricity with a new windmill. Next slide. And we go for a few minutes into that slide, because here we can see the 7 recommendations of the Commission of the European Union, and these are actually the right answers. And that what should we do? We have to look at these recommendations and to follow these ideas. That's what we anyhow thought before the EU Commission had that idea, but it's, that's not the fault of these recommendations. So we just go around the circle from starting at the top and see that the first recommendation is that renewable energies plans should be subject to the most favorable planning and authorization process. And we have that now within our law. Anna will tell us about that, if different interests have to be handled, then the interest or the purpose of building a new plant for renewable energy has to have more weight than the other interests of the neighbors and so on. This is one crucial point. We'll talk about that as all the other points in a few minutes. The second recommendation is to shorten the permit granting process, and there is some more like a provocation actually that is said you have to finalize, you have to get a permit within 3 months for some solar plants, but you will see that we will be happy if it would be possible to have a permission for building and running a windmill within 3 years. That would be a big success. But this is what we're talking about. The third point is that we need a better coordination between the public levels. As you know, in Germany, we have in France it's not so different. It's different, but not so different. We have the regional and local level, the regional, the Länder level, and the federal level, the nationwide level. And we have laws, and we have decision maker, we have administrations, and all levels, and everybody wants and has to say something. And coordination between these parties is of crucial importance. The fourth recommendation is the question if we can pre-decide some decisions that has to be made within the process of the permission granting. There are some situations where it is possible that we say, yes, it's okay for me if you, the other administration, is doing that or that, if you do that without asking me for every case, because if you do it in the schema A, then it is okay. This is a situation that maybe could bring some time within the process. The fifth recommendation concerns the idea that there could be some areas within the country where it is no problem to build windmills at all. So the designation of go-to areas of not, so it's this recommendation, which is the opposite of what we had in the past, where there were no-go areas. Eignungsgebiete are the go-to areas, and the restricted, secured because of landscape, whatever areas where you can't go. So one idea is that you divide the one areas from the other areas and open the doors for the areas where it is easy to run windmills, where you have good wind conditions, and where you have comparatively not so much problems. So this is the fifth idea, which is also a very good idea of the Commission. The sixth idea is concerning the participation procedures, public participation of the neighbors and all the other private persons who also want to get an opinion about the future windmill and around where they live or work. And this should be done in the future as far as possible on a digital way. So not meeting and discussing and fighting against each other, but do it as far as necessary web-based, which also could be helpful, because then you will have less time problems. And the seventh recommendation is concerning the natural survey security and the natural conservation law. So we're talking about birds, especially, not only, but mainly about birds and the distance between the nest of a bird and the windmill. And the idea is to make it more concrete what has to be done, or what is allowed and what is not allowed from the very beginning of the planning process. If there is, for example, an eagle nest 20 meters or 500 meters or 2 kilometers away from the windmill. So what are the legal consequences within nature conservation law if that is concrete earlier and generally decided within the law? Then result of the procedure to get a permit permit is much more foreseeable and could be fastened. So these are the main recommendations, and we will go through our whole speech with these proposals. So we come to the next slide, please. The next slide, please. This is the duration of the procedures at the moment. There's an example for a windmill, and you see how we come to 7 years of planning and going through this procedure, which is not necessary. We have first approximately 3 years of regional planning, and after that we often have cases at the court that say the regional planning was wrong, and then the 3 years are not the whole truth, to be honest. And then we have location check and securing space. So all the questions on the local level that has to be decided for another year at the moment, and then we have just the handing in of the documents within the procedure to get a permit, and then we have the 3 years to get the permit at the end, which is much too long. So next slide, please. Here you can see, unfortunately in German, the most obstacles at the moment to get a permit quickly. And this is not only, maybe we just go, you can see there in German as you understand it, but we go to the next where you can see all the topics again. Next slide, please. Here you can see which reasons are of great importance for the long duration of permit processes, and the most you see the blue line and column, the blue column, and this is regional planning. So as I already said, there is a really big problem with the stability of regional plans, because as we say as lawyers, in planning, in public planning, there are always mistakes. There's no public planning without a mistake, and if you're against wind and energy, then it's really easy to find something if you're an expert and to say, please make it again because there is a mistake and there is a mistake. So this is the crucial problem, to make a really secure, complete regional planning. And this is the main problem within our system. So the next, you see that it's on the regional level. So on the for example, parts of the Länder are part of the regional planning in Hamburg, for example, where we are. So, and the local Gemeinde, the local level is the second point of importance for that, but as far not as important as the regional planning. The second topic that is of problem are this species protection, so natural conservation, the birds and the badlands around the wetlands and hamsters. These are the other problems. The second important problem could be the same in France. Then are following flight security, military flight security, weather installations, and for example, that you have to change the type of the windmill or which is, as you know, quite common within this process. That could cause some weeks of longer duration. So these are the main obstacles. Next slide, please. And so we have the result that it is, as I already said, this is not the question of the money or of the subsidy system, or that, you know, wind electricity is one of the cheapest electricities at the moment, and green and without. So it's everything is for wind and solar, but we have the problem with permits and integration, with unnecessary steps, and the procedure is much too long, and we have to readjust that immediately. So Anna, please go on with some possibilities that our lawmaker is going to introduce or has already introduced.
Thank you, Martin. Next slide, please. So we're tackling now the question, what has been planned or done already in Germany, and our first look will be to the changes in planning law. As you have seen, as Martin has explained, planning law is the major obstacle for the long duration of permit granting procedures. Next slide, please. And so, how will Germany do this? First of all, appropriate areas must be available, which are not at the moment. And the areas that have been designated so far are far from sufficient right now for the very ambitious targets for onshore wind energy. As you can see, 1.8% of Germany's land area is designated for onshore wind energy, but we're now currently at 0.5%. So, as Martin already mentioned, the spatial or regional planning in Germany takes place on different levels, on the regions, in the municipalities, and all the authorities and different actors and stakeholders have to interact with each other. As you can imagine, that creates a lot of conflict that has to be solved subsequently. Next slide, please. On this image, you can see the different planning levels that occur in Germany. You have, like in dark green, the European Union, and less dark green, the federal level in Germany, then the land and regions. And you can see that if, for example, in the east, you can see like Mecklenburg-Vorpommern, the land of Mecklenburg-Vorpommern, if you would erect or would like to install a wind turbine next to the city of Rostock, then you would have to like have a lot of actors and stakeholders as part of the procedure. And yeah, as Martin already mentioned, this can take up to 7 years if everybody has their say, and there are a lot of conflicting interests which have to be matched and against each other and balanced by the competent authorities. Next slide, please. So, as we've mentioned already, the planning law serves in the first place, the designation of wind energy areas, or as the Commission told them, as go-to areas, and therefore has a control function. Right now, wind turbines or windmills are privileged in the concept of the German planning law in the so-called outside areas, or for the German speakers among you, the Außenbereich in the German construction code, but only if their erection does not conflict with other public interests, which have to be balanced against them. And additionally, the conflict with other public interests is assumed if other priority areas have been provided for wind turbines, but the wind turbine is not to be installed in those specific areas. Well, we see this current situation as very prone to errors and disputes, and that's what people in the field experience every day. And so the next idea and step to be taken is to designate priority areas for wind energy and have therefore an exclusion effect for other conceivable areas which should then be void of wind turbine installation procedures. Next slide, please. Martin has basically explained the intended upscale of the wind energy targets, and as you know, it's very ambitious, and from 2027 on, there's going to be an installation of 10 gigawatts per year. So in order to meet this goal, we have to do a lot, and therefore we go to the next slide, please. So to sum it up, you can see that around 2030, there has to be 150 gigawatts of wind energy, which is then even upscaled to 157 gigawatts in 2035 and 160 in 2040 and beyond. We are far from this goal right now. And as you know, the planning and realization periods for the approval and also the construction actually need a lot of preliminary time right now. Next slide, please. So in Germany, the Wind-an-Land Act has been introduced or became effective in the summer. And as I said before, we are currently at 0.5% in the country of Germany's territory is actually available right now for wind energy. And so this should be upscaled to 0.8%. And the problem for the lawmakers in Germany is that they cannot exert direct influence on the municipal and regional levels on the authorities there. They can only influence the legislation. And they did this by designating more available land for wind energy. Therefore, they passed the Wind Area Requirements Act, or in German, the Windflächenbedarfsgesetz, and are on the way of drafting amendments to the Federal Planning Code and the Renewable Energy Act as well. Next slide, please. So these are the answers addressing the German planning problem. So in the Wind-on-Land Act or the Windenergieflächenbedarfsgesetz, they upscale the targets from the 0.8% to 1.4% and in 2026 and 2% in 2032. And on the arrow down here, you can still remember the targets we have mentioned, and you see that the goals more or less correspond with the gigawatts target that should be achieved. Could you go to the next slide, please? Thank you. So now the federal states, or the Länders as we call them, I think also in French, have two options to implement the new requirements. On the one hand, they could pass an independent definition of those land use targets on their regional spatial development plans. That's the way we translate it from Ordnungspläne in Germany, so that those are plans that are adopted on the broader regional level, but it's not like the Länder level, but it's like for regions within the Länder. Or they could use a definition of the land use on their lower planning levels, which means on the so that it would be part of their planning spatial objectives to be adopted in the different plans. And the consequences of a breach of the requirements would then depend on the choice they made to implement these goals. So in order to get the Länders to meet their goals and to achieve the targets, there was like a new means implemented that's called in German the Flächenampel, which we translated into traffic lights for the area, which is obviously just a rough translation. So they have to report to a cooperation committee among all the Länders in German called the Kooperationsausschuss, and have to report on the status of the implementation of their area targets in their land. So the idea is, that's why we put down the icons down there, that they have to talk and to show their results. So prevent the Länders from blindly, if they could ever, missing their area targets until the sanction rules take effect. The sanction rules are basically that wind turbines then will be privileged in the outer areas, the German Außenbereich, and the Länder can do anything against it, and then they will end up with like wind turbines in places they don't really want to have to be. Next slide, please. So just to show you a couple of figures, of numbers here, you could see, for example, picking like Bavaria, they have to contribute more or less against their will 1.1% of their area for wind turbines until 2026 and 1.8% until 2023. As you can see, like smaller like cities like BE for Berlin, they have obviously less space, and therefore they have to contribute a far lesser amount in the next 10 years. You can have a look at the actual numbers probably later on. So please go to the next slide. We will now come to the amendment. Yeah, okay, fine. So the amendment changes in nature conservation law. We had Martin introduced already the problem of let's say the conflict between birds, hamsters, and bats and wind turbines or windmills. So actually, it sounds like a little bit funny, but it's not funny at all, because we not only face the climate crisis, but also a species like a biodiversity or species extinction crisis, and both need to be addressed simultaneously, and it's a serious issue. And for Germany, it's like for all EU countries, it's pretty obvious that there's only a small leeway that the EU member states can actually address in their legislation, because a lot of the European law has already been passed and has to be observed by the EU member states. So, for example, the Bird Protection Directive and the Natura 2000. And another problem that's just very particular to German law is that the implementation of the requirements in the Länders is especially unclear, and many authorities can more or less use their discretion as they want. Next slide, please. So, as Martin already mentioned, and the idea to address this problem on the Länder level was to pass a uniform federal standard for the species protection assessment, and that should and in clearly defined zones which are now regulated around the wind turbine. So, as you can see, there were many debates also between the Länders. For example, there was apparently a problem for wind turbines between the land of North Rhine-Westphalia and Lower Saxony, and they where the competent authorities had different assessments of the effect of the windmill to areas in their land. And generally, the hope is that this federal standardization on a federal level will have an accelerating effect, while even the high ecological protections are observed, because the Länders then cannot discuss these questions anymore, because it will be solved on the federal level already. Next slide, please. So now we would come to one of our last points. This is the changes of the Federal Building Code and the Spatial Planning Act. Next slide, please. So the German government just introduced last Wednesday, I think, a new proposal to change the Federal Building Code in order to have wind turbines or windmill privileged outside of populated areas. That means that actually they are they're in the balancing of all the public interests. They should be favored over other interests. And another addition to the already amended German building code, Federal Building Code, is that wind turbines shall be now erected or made like the procedure or the process to erect them should be made easier and sped up, and if they are erected on former brown coal or lignite mine sites. So the planned entry into force is scheduled for February 1st next year, but is still in the legislative process. Next slide, please. We talked already about the spatial planning. Then this sets up a lot of problems on all levels, and therefore this was also addressed by the federal government in their draft amendment last week. As we said already, they do this by designating the wind energy areas. The idea is that there's no more overall spatial planning concept necessary, and if wind turbines are actually to be erected in such an area, then the environmental impact assessment, or Umweltverträglichkeitsprüfung in German, can be skipped, and also the species protection assessment for birds, that's what we mentioned earlier, which was like a suggested solution for this problem. Obviously, this is not the case for wind turbines that are planned in national parks or so-called Natura 2000 areas. Actually, also the problem for the our computers when are shut down soon, hopefully not. That this amendment can only enter into effect after the EU changes some of their acts, especially the Conservation of Natural Habitats and Wildflora and Fauna Directive and the Directive on Wild Living Birds. Next slide, please. So what is still on the table, I will just skip this because Martin has mentioned this already. So we are talking about simplification of administrative processes, digitalization, to have the public discuss more online and not in person. Another problem is that we need more qualified personnel, definitely on all of the concerned authorities, because we don't have enough staff to process all those applications actually. And another idea is to accelerate court proceedings, which was also addressed last week by the German government. Next slide, please. So I would like just to come briefly to this draft of the amendment of the administrative court code or Verwaltungsgerichtsordnung in Germany. So they want to simplify the administrative court proceedings by just starting the whole procedure at a higher administration court level already if wind turbines with a height of above 50 meters are concerned, and also obviously offshore territorial wind turbines in the territorial sea. And there a new procedure for urgent legal protection for infrastructure procedures is introduced. For those lawyers among you, it's section 80C now, and the court proceeding should also be accelerated. And also there should be more specialized judges for those proceedings. Next slide, please. So yeah, the question we are asking ourselves, what more is to be done? Basically, we've run through all the proposals and all the ideas to address those problems. We think that the discussion should also be held both on the national and the EU country levels and the EU level. But we see that there's a lot of progress made on the by the Commission, and we're really looking forward to see those ideas implemented. Next slide, please. So that's our last slide, and this is something that actually is addressed a lot by NGOs dealing with wind energy. That's the conflict with monument protection. I think it's a very German thing, also because it shows the German legal system very well, because monument protection is addressed at the Länder level, and there are many people in the monument protection authorities who actually don't like windmills disturbing the view of monuments. And as you probably know, the overriding public interest of renewable energies has been implemented in the German Renewable Energy Act, but is not automatically to be applied on the Länder level. So we just hope that there will be also an improvement regarding the monument protection acts of the Länders. So that's what.
Next slide, please. Last slide. Thank you, Anna.
Thank you very much for your attention.
Thank you very much for your attention. You can see our addresses. And I also would like to mention Christophe Lavie, our French-born colleague in our team, who also is keen on getting in touch with you if you need also something.
Thank you.
Thank you very much.
Thank you very much, Martin Altrock and Anna Dost, for this very interesting presentation on the situation in Germany. We could now come to France, and I would like to hand over to Anouk Darcet-Felgen. And for you, our listeners, please don't hesitate to send us your questions during the presentations. I see some are coming in. And we would like to have some of them ready for the Q&A session after this presentation. Thank you very much. Anouk. I can't hear you so far. Maybe, I don't know what's wrong with the microphones today.
Hello, good morning, everybody. Can you hear us?
Yes, we can hear you loud and clear, so please.
Thank you very much, Sven. Actually, I will give the floor to Laurence, which will start with our presentation.
So good morning, everyone. As Sven told us earlier, you know that France failed to reach its European target regarding renewables for 2020. Which will cost us a lot of money, according to our energy transition minister. And the targets, the current targets, are now set in Article L111-4 of the French energy codes regarding renewables altogether. And according to this article, France aims to increase by 2030 the share of renewable energy to at least 33% of gross final energy consumption and 40% of electricity production. Excuse me, I forgot to tell you, we have to move on to slide number 1. Thank you. Regarding onshore wind energy, the objectives are set by what is called the French Multi-Annual Energy Program, which was set in 2020. And I assume you will find that our targets are ridiculous compared to the one you just presented us for Germany, because the plan is to reach 24.1 gigawatts installed by the 31st December of 2023, and between 33.2 and 34.4 by the 31st December of 2028. So we are very far from the figure she just gave us for Germany. It's kind of ridiculous. More recently, in a speech he gave on February 2022, our President Emmanuel Macron said that he wanted to double the installed capacity of onshore wind farms in France in order to achieve 40 gigawatts by 2050. And even though those figures are very low, we are very far from getting to reach them. So now we are moving on to a different step. And since the 26th of September of 2022, a government bill is being discussed before the Parliament. It's called the Bill on the Acceleration of Renewable Energy Production. And it contains various provisions which are supposed to help us achieve these objectives, but unfortunately also many provisions I will see that create new restrictions for the development of onshore wind farms in France. Next slide, please. So to date, the legal framework which applies was set by the last big reform, which took place almost 6 years ago. It was in 2017, by one order and 2 decrees of the 26th of January. And one of the major change that was made by then is that onshore wind farms, which are now subject to what we call environmental permit, we will talk about this permit later on, are exempt from building permit. So this rule is set to date in an article of the French Urban Planning Code, which is article R425-29-2. But this doesn't mean that onshore wind farm does not have to comply with the urban planning regulations. So first of all, we have to know that Article 8 L151-15 of the French Urban Planning Code provides that municipal and intracommunal urban planning documents, which we call in France plans locaux d'urbanisme and plans locaux d'urbanisme intercommunaux, may allow the implementation of onshore wind farms in areas where it's normally difficult to build, barely allowed. And these areas are called agricultural areas, les zones agricoles, or natural areas, which we call zones naturelles. A first change was made this year by a law we call La Loi 3DS, which created a new article in the French Urban Code, Article L151-42-1, which said that the formation urban planning documents may define areas in which onshore wind farms will be subject to specific conditions. And to this end, the municipalities which are concerned to create those areas will be able to amend their urban planning document by the simplest amendment process we have for these documents in French, which is called the procédure de modification simplifiée. Just very quickly, there exists 4 different ways to modify urban planning documents in France, and this one is the only one which does not request a public inquiry. So it's supposed to be easier, but also faster. And in its current wording, the Article 1BA of our government bill provides for the establishment of a new kind of plans which do not exist to date, which are territorial landscape plans, plans territoriaux de paysage, which will also depend on the French urban planning code. And they aim to define, among other things, landscape integration objectives for energy production facilities. So it's hard to know yet what will come out of this, but unfortunately it seems to be a new restriction. Next slide, please. Are the two other articles that I would like to mention regarding the new layout rules, which are currently in the government bill. So the first one is in Article 1 CBA, which provides an amendment of one of the article of the French Environmental Code, which apply to onshore wind farms. And to date, it states that the environmental permits, les autorisations environnementales, for wind farm, for onshore wind farm, must take into account the production capacity of the wind farm, the number of already existing wind farms in the area concerned by this project, and the need to diversify renewable energy sources and to prevent what they call visual saturation effects. Another article we would like to mention is Article 3 of the bill, which foresees the creation of new zones, les zones d'accélération pour l'implantation d'installations de production d'énergie renouvelable, which could be translated as acceleration zones for the implementation of renewable energy facilities. And to date, we are just hoping that this creation of these zones will not restrain and make it possible for developers to build wind farms in areas outside of this zone d'accélération. But it's like unfortunately too early to know about this. Next slide, please. So I've already mentioned to you the authorization which applies to date since 2017 to onshore wind farms, which is called the authorisation environnementale, environmental permit. And so the reform had the advantage to create a process, a permit contingent process, which includes all the different permits which might be required for the construction or the operation of an onshore wind farm. So for instance, it includes the former operation permit, which is required in French for classified installation for the protection of the environment, among which the onshore wind farms, but also another kind of operating permit, which is delivered under the French Energy Code, which is a permit which allows to operate electricity generating facilities. It also includes what we call a permis de défrichement, autorisation de défrichement, which allows you to have trees cut down when you have to have them cut down in order to build the farm. Or, for instance, authorization requested under the Heritage Code, which is meant to protect historic monuments. Next slide, please. But another very important, actually it's not an authorization, it's a derogation, which is also included to date in the environmental permit, is the derogation to the prohibition of destruction, alteration, or degradation of protected animal or plant species, which was mentioned earlier because it stems out from European law, so we all have to apply it. So to date, according to Article L411-2 of the French Environmental Code, This derogation may only be granted if three conditions are fulfilled. The first one is that you are supposed to establish that there is no other satisfactory solution. The second one is that the derogation may not affect the maintenance in a favorable state of conservation of the population of species concerned in the natural area of distribution. And the third condition is that the exception has to be justified by one of the five grounds which are restrictedly listed in this article L411-2, among which there is only one that we can use for onshore wind farms, and it's the famous imperative reason for overriding public interest. So very interesting subject, because in its first original wording, the government bill we've been talking about intended to add a new article to the environmental code, stating that the last of those three conditions, that is to say the overriding public interest, is deemed to be recognized when the project regards a renewable energy production facility. So it was deleted from the bill by the Commission on Economic Affairs of one of the two chambers of our Parliament, l'Assemblée nationale. But yesterday, during the public session which took place in front of the same chamber, the subject was brought back to discussion thanks to a governmental amendment which wants to create this new article L411-2-1 of the Environment Code, but also wants to add a new article to the Energy Code, which basically we say the same. So hopefully this will help us to get permits, to get this derogation, that is, and therefore to get the permits for building and operating onshore wind farms. But also, unfortunately, this will not be sufficient because we still have to fulfill the two other conditions, which are a little tricky because not very clearly defined. But still, we're hoping that this amendment will stay in the bill. So I will now let Anouk present you the permit granting procedure. So could we please move on to the next slide?
Thank you, Laurence. Yes, so let's have a look at the current administrative permit granting process. The instruction of an environmental permit consists of three phases: an examination phase that should normally last up to 4 to 5 months, a public inquiry phase that should last 3 months, and a decision phase that should last 2 to 3 months. But in practice, the examination phase is frequently suspended due to the administration's request for additional documents and information, as there is no binding deadline for this phase. According to the European regulation of December 11, 2018, the permit granting process shall not exceed 2 years. But in fact, so far in France, the whole instruction process can last up to 6 years, whereas the average duration normally is around 3 years. So that's much too long, and that's really one of the main obstacles for the deployment of the quick deployment of renewable energy projects. So next slide, please. So the government has foreseen some amendments of the administrative permit granting process, providing for rules that will apply to the applications filed within 4 years, so not 2 years, of the enforcement of the law. So, for instance, the developers shall not be able to request the Préfet to provide them with a project certificate, as they could do until now, so in order not to delay the filing of the request for an environmental permit. The Prefet shall be able to reject applications for environmental permits during the examination phase, so even at the beginning of the examination phase and not only at the end of this phase, it's the case right now, if he considers that the file shows that the requested permit cannot be issued. The public inquiry shall last 30 days, whereas so far it's a minimum of 30 days, and will not be extendable by the investigating commissioner. So these rules should allow to speed up a little bit the permit granting process. Also, referring to the Préfet, référent à l'instruction, shall be appointed in each department to facilitate the administrative procedures for developers and to coordinate the work of the administrative units responsible for the permit granting process. Next slide, please. So right now in France, there are some specificities of the legal proceedings relating to environmental permits for onshore wind farms. So since 2018, in France, the administrative courts of appeal are competent to rule in the first and last instance on all matters related to permits for wind farms. So this has been an important improvement, allowing for a shortened litigation phase. Also, it is not possible for the claimants to raise new legal arguments more than 2 months after the filing of the developer's statement of defense. The Administrative Court of Appeal has extensive powers, as it can postpone its decision in order to allow the file to be regularized in case of an irregularity or flaw, and it has the power to grant the environmental permit itself. But all the provisions foreseen in the initial version of the government bill to limit appeals against environmental permits, such as the obligation to notify the appeal, the restriction of persons entitled to file an appeal, the possibility for the developer to claim compensation for abusive appeals, have been so far deleted from the current version of the bill. Next slide, please. Regarding the implementation of environmental permits, the commissioning of an onshore wind farm is subject to the provision of guarantees to ensure the completion of site restoration operations at the end of the wind farm's operation in the event of the operator's default. The government has proposed the following amendments in its bill, saying that the Préfets may subject the construction or commissioning of new onshore wind farms to the operator paying for equipment to compensate for the inconvenience caused by its facility for the operation of military detection equipment, radars, and navigational aids used in support of civil air navigation, which is Article 16 bis of the current government bill. So this aims to facilitate the acceptance of the project by the Army and the civil navigation authorities, who have to give an opinion, a favorable opinion that is binding for the Préfet. The next slide, please. Regarding the current rules applying to the renewal of onshore wind farms, currently, if you have significant modifications of the existing onshore wind farm, they must be reported to the Préfet before their implementation, and the substantial modifications are subject to a new environmental permit. The government has set out guidelines in its circular of July 11, 2018 for assessing the nature of modifications to onshore wind farms. So any increase in the number of wind turbines constitutes a substantial modification. The renewal of the turbines with turbines of the same dimension and at the same location requiring work on the foundations constitutes a significant modification. The modification or replacement of an identical part on the wind turbine does not constitute a significant or substantial modification, and all other modifications are subject to detailed analysis by the administration, so that you cannot really know in advance whether you will need a new environmental permit. The government bill provides that environmental impacts of the renewal shall be assessed in relation to the potential impacts resulting from the modification or extension in relation to the existing facility. So this should simplify the process. Next slide, please. Well, we have given you an outline of the permitting procedure for onshore wind projects and the current main amendments of the government bill. I would like to focus now on two other legal documents that could accelerate the deployment of renewable energy in France. First of all, we have to mention the government circular dated September 16, 2022, which is supposed to really speed up the deployment of renewable energy projects. And it requests the prefectural services to put in place all the necessary actions to accelerate the instruction of the files being currently examined, which represent nearly 10 gigawatts of solar and wind projects. So that the current that instruction time will not exceed 24 months and 18 months for repowering projects. The Prefet should study the timelines and come up with solutions for the projects of more than 5 megawatts, having been instructed for more than 12 months, and every third month, the Directorate General for Energy and Climate shall monitor the compliance with the instruction deadlines. There shall be no use of consultation bodies that aren't legally necessary and no consultation of non-essential commissions. And the Prefet should now grant without any delay, deliver without delay the permits that have been granted pursuant to a court decision. And also there should be no more automatic requests for revision by the Ministry of Ecology in case of a defavorable decision. But so far, so this has been like, it's been like almost 3 months ago. So far, apparently there is no impact of this circular, and there are 2 gigawatts of onshore wind projects that are just waiting for the signing of the environmental permit by the Prefet, and 3 more gigawatts which are different phases of the instruction process. So this circular, well, it has the possibility to really accelerate. So far, we haven't seen the impact, but we can hope that this will come. Next slide, please. I would also like to mention the proposal for council regulation laying down a framework to accelerate the deployment of renewable energy of November 24, 2022. Because in a nutshell, it says that the planning, construction, and operation of plants and installations for the production of energy from renewable sources and their connection to the grids and the related grid itself and storage assets shall be presumed as being in the overriding public interest and serving public health and safety with regard to environmental rules. So, renewable energy projects are presumed to be in the overriding public interest. This proposal is normally going to be adopted, I think, on December 13th, so very soon. And I would also like to mention the directive proposal made by the Commission within its Repower EU plan, which actually contains the same provision and also presumes that renewable energy projects are in the overriding public interest. So if we go to the next slide, please. Coming to our conclusion, which is that the current version of the government bill, unfortunately, rather than accelerating the deployment of renewable energies, is well, rather slowing it down. And of course, the final text is only to be voted at the end of January 2023. The debate in the public session of the Assemblée Nationale has only started yesterday, so we can hope that the final result of this bill, yes, will contain more measures in favor of the deployment of renewable energies. As we have seen on the European level, well, this proposal for Council regulation laying down the framework to accelerate the deployment of renewable energy, once adopted, will be directly applicable in the member states and legally binding on the administrative authorities and on the courts. So if the French Parliament in the end refuses to vote the measure that would simplify the obtention of the derogation for to the prohibition of destruction of protected species, it would not be very efficient, and the presumption of overriding public interest of renewable energies will anyway soon be positive law in France. Also, the government can act by monitoring closely the implementation of its instruction to the préfets and give their services the appropriate human and financial resources to take the necessary actions. So we can say that there needs much more to be done in order to accelerate the deployment of renewable energies in France, and that given the current composition of the political landscape in France, the speeding up of the deployment of renewable energies on a European level seems the quickest way to accelerate its deployment in France. Thank you very much for your attention.
Thank you very much, Anouk and Laurence, for this interesting insight into the situation in France. I think we have loads of topic for the next 20 minutes and our Q&A session. For you that are following us, please do send us your questions. We received quite a few already, but we can take yours into account also. There's a lot of interest about the issue of overriding public interest. Maybe you could give us just in a nutshell your decision or your analysis of what that will actually mean, also maybe in terms of time and effort to be put into instruction in the future in comparison to what we saw over the past years in Germany and France. Maybe Becke Büttner-Held first, Martin Altrock, and Anna.
Oh yeah, okay, this time it's working. Okay, yeah, thank you for this intensive discussion, also a legal discussion about the effect of the overriding public interest. And I think some of you are interested in that. There are several articles that you can read and maybe translate it to French or English as well. And my understanding now is that we should not expect too much of that regulation, because at the end it's not possible that just because there's an overriding of public interest that the results will be very different. I think just in specific situations where it's close to go on that side or on that side, it will help to come to the side of the renewable energy power plant. But it is clear actually that if you look at the constitution, that it's not possible to have a completely different decision making within the natural acts. So the Bundesnaturschutzgesetz, the results of the law could not be that different just because of the overriding public interest. So we should not expect too much of it. That's what actually, in my opinion, after some contact with the arguments against and for these.
Okay, thank you very much. So it's not magic solution. And for Anouk and Laurence, maybe your assessment of this question. We got more questions on this from France than from Germany, so.
Yeah, we're not surprised now. We still have the problem. As I mentioned before, there are still up conditions will have to be filled to get this derogation. And since they're not very clearly defined, it's hard to tell whether it will be that much easier to get this derogation. If it cannot hurt, that's for sure. But we still have to prove that there is no other satisfactory solution. And it's not easy to guess what the administration and the judges will mean by that. And we have also to prove that the derogation will not endanger too much the concerned species. And on this matter, even though some préfets are quite willing to grant the derogation, it's not that clear for the administrative courts of appeal, which do not all have the same position on the subject. Should find out, I think next week, the Conseil d'État is going to deliver a decision on the subject to make it clearer whether the killing of only one bird, for instance, is acceptable or not, whether it would be sufficient not to grant the derogation. And as you may know, and maybe that's why we have questions about that on that matter, a French developer was convicted by the Cour de Cassation, which is a upper judicial court in France, for bird killing. The faucon cresseret. So maybe that's why we have questions on the subject. So it's not that clear. Of course, it would help if the bill remains this way, but that won't be enough. And what the bill says to date is that the wind parks, we have to fulfill some technical conditions so that the derogation is granted, and we don't know yet what these technical conditions will be. They will concern the capacity of the wind farm, and they will be set out by a decree. Will come later on, and that means that unfortunately the wind parks will not fulfill these conditions, will have problem getting the derogation.
Thank you very much. One question for Martin Altrock. We heard from Anouk that in France there has been this tendency in the past years towards at the department level to ask non-mandatory documents for instructions, which has often been told us to be one of really the big problems developers are facing in France. Is this something you also see in Germany?
Maybe Anna
I will try to address this, but I'm not so much familiar with the French administrative process as I should be to answer this question. But as far as I understand, like non-mandatory means that there are like extra papers that have to be filed for French colleagues. And I think this is not the case in Germany. I mean, it's something that this is for once a problem that we don't face.
Okay.
I think there's a quite precise catalog of requests that have to be worked with and then the conclusion. But you can't become in a better position if you have some additional information. This is not something that's known from you.
Okay. Thank you very much. And for Anouk and Laurence, how would you assess the impact of the new regulation on this aspect? Will this situation evolve, or would you believe that this will remain a problem?
You speak now about the instruction to the Projet.
Yes. Yeah.
Yes. Well, yeah, we can hope only that, I mean, it's only been 3 months since this instruction has been given to the prefect, so apparently it's starting to have some effect. And yes, well, also as we said, well, I think also maybe a problem of having enough resources, human resources, having enough people that are able to follow up and to yes, to get the work done. So that could the government also plan to in its draft of bill for 2023 on the budget to have some more resources. Also, so far this amendment has been rejected. Yeah, so we will hope that there will be more follow-up of this instruction, which could really very quickly accelerate the deployment of projects. If there are 2 gigawatts of projects only waiting for signing of the environmental permits, so this could be done very quickly.
Right, thank you.
The political aspects, I mean, the prefect have to follow.
Yes, of course. And talking about this, I mean, there's obviously currently in France a huge debate in the media going on about the new Renewables Act or a new Renewables Acceleration Act. I saw an article in the Figaro yesterday by Architectes de Bâtiment de France, also from environmentalists. How do you assess like realistically what will come out? We saw your conclusions. What will this change? Also keeping in mind, of course, that the IEA says that by 2050 we will require twice as much as electricity as we need today. Will this put France on the right track towards this type of target?
Be very optimistic.
Yes, well, as I said, I think that there should. I think what will come out of this bill will not be enough. So it will be first step maybe, but there need to be more action taken, and that's why, I mean, on European level, also with the directive, the proposal of directive by the Commission now to amend the renewable energies directive also contains provisions that should help to accelerate the whole permitting process. And so this directive, of course, then will have to be transposed in French law. But yeah, it's going to take some time. But if we have to be optimistic and yeah, hope that this will quite quickly allow to have all the projects that are actually in instruction phase, and the more that in plans right now in development to be able to get constructed and we'll be able to operate quickly.
Thank you very much. And maybe from Anna Dost and Martin Altrock, also an assessment of what actually changed the new or what will change with the new regulation in Germany. Targets are sky high in Germany, also for even if it's not so ambitious as it is, for example, for photovoltaics. Would you believe that, I mean, we saw your curve for development volumes over the next years until 2030 and beyond. Would you say that the legal situation now in Germany that has been established, will this make a significant difference? Do you see the first signs of it? What would your assessment be for this?
Unfortunately, there are no first signs that we have an acceleration of the procedure at the moment. I understand that especially because with the green, also green government now, this is something like a last chance, the last try to make it really fast and yeah, to get as much as possible. But we will see, maybe in 1 or 2 years, we will see if there is a success. We need that success, but especially also what was said by Anouk just before, that we need also, Anna also said that we need a lot more people working within the administration to do that. And as long as we are not going to have more experts and willing people, open people in the administration, this will not come to the good. And so this is something that really has also to be changed. So then if we have the people and we have the law, then see something could come to a solution. But the law for its own is not enough, even if it's as ambitious as it's now. If I look at French law, I have the feeling that at the moment you have some things we would really like to have. So 1917 was quite good reforms. Just look on the duration, so it's great if you would have, we could come close to that a little bit more, then it would be really good. So I'm not so pessimistic about the functioning of the administration in France. So maybe just.
Okay, thank you very much. I'm looking at the clock and time's up already. Thank you very much for your participation today. Anna Durst, Martin Altrock, Anouk Dasset-Felgen, and Laurence Durier. This was really very exciting. I would just like to make a few announcements before we sign out. Thank you ever so much for your interesting and enlightening input and replies to the questions of our listeners. I think you gave us all a lot to think about and made the current state that wind energy onshore in Germany and France is in much clearer for us from a legal perspective. Many thanks also to Lucy and Emma from our team for setting up this webinar and the technical support today. Now, before we sign off, just a few announcements for your agendas. Coming up next at the Franco-German office, we have tomorrow on December 7th, a political debate on the impact of the current energy prices and decarbonization regulations on the industry with high-level speakers from the European Commission, science, the renewable energies community, and industry at the German embassy in Paris. This event is now booked up, but you will find the audio files very soon on our website. And we will finish the conferences in 2022 with an online conference on large-scale rooftop PV on December 13th, with many interesting aspects, including business models like self-consumption and corporate PPAs. And we still have a few places left, so do make sure to check the article on our website and to sign up if you're interested. You will find more detailed information on all our events, also for the next year already, on ofate.eu or dfpew.eu, where you will also find very soon today's slides and also the videos, of course, and many interesting publications for you to download. Maybe that makes a good reading for the holidays. And please do make sure that you are on our mailing lists to stay updated on our upcoming events and other initiatives. This is all from my side for now. Thank you very much for joining in and tuning in today. I wish you all a good day. See you very soon. Bye-bye.